Hi friends, my name is Advocate Ajay Dubey and today I am here to speak about the Negotiable Instrument Act, drafting and filing of Negotiable Instrument Act. First of all, as a layman, we have to understand what actually Negotiable Instrument Act means. The Negotiable Instrument exclusively speaks about the negotiable instruments. The instruments are those which are used for a commercial purpose, non-commercial purpose, just to carry out or facilitate the trading activities. So there are various kind of instruments which are there in the practices. Most preferably used is the check. Second, subsequently, is the bills of exchange. So, being a layman, we can know that either of the instrument presented for the remittance or the final payment, and if it is dishonored or not accepted for the payment, in such a situation, the person can file a criminal complaint. However, we have to understand the instrument is used in the civil practices. However, this particular section has been shifted on the criminal code to trial this particular prosecution merely to expedite the trial, so has to the person who are in the trade can easily recover the money and can continuously use the fund which is required for their commercial activities. Coming to the second and subsequent more valid options, as a layman we always think if a check got dishonored on the presenting before the particular bank, what are the procedures which we have to follow. So basically I will like to tell you there is a simple formula. We can say 1530 1530 1530. I hope you can understand what does it actually mean. The day when we present the instrument in the bank for the payment or honoring of the check, and if the instrument get dishonored, the date on which we receive the memo, from the date of that particular memo, we are entitled to issue a demand notice within the period of 15 days. Mind my word, it is within the day 15 days. That means if I receive a memo on particular date, that means subsequently from the next day till the upcoming 15 days I have to issue the demand notice. And in that particular demand notice there is going to be a clause for a reasonable duration for the remittance of the payment, that is going to be a 15 days. So that means the date on which I am going to issue the notice, from the date of that particular date, the 15 days I have to wait. And as soon as the 15 days get over, or the date on which I have issued the demand notice, from that day, the upcoming 30 days, I have to institute a criminal complaint against the party for the non-payment or non-remittance of the particular amount. My dear friends, there are few questions which I have came across being in the practices. There are a lot of ambiguities with respect to the duration of tendering the notice and the duration of filing the complaint. So getting it much more simpler for the people to understand, the rule is 1530, 1530, 1530. So I think my friends are very much clear, and with respect to the jurisdiction, it is very much clear. Even though this particular matter is sub judice in the civil segment, even though the proceeding is followed under the criminal code. Now we have to understand the jurisdiction of the courts. Basically, when I'm talking about the urban area, the city's chief metropolitan magistrate or the metropolitan magistrate are entitled to trial this matter. Whereas when I'm speaking about, exclusively speaking about the rural area, then JMFC, that is Judicial Magistrate First Class, can trial this matter very precisely. Now the second question which most of the people ask, if the party refused to make the payment, and if there is a lapsation of a duration of servicing a notice, or there is really a prolonged duration has been passed and this check has been lying unattended even after the dishonor, because there has been a commitment made by the party that is going to honor by making the payment. So there are the two procedures which I will highly prefer and suggest all my colleagues to follow, is that either you can represent the check in the particular court if the check is not stilled. because we know that any instrument, basically and specifically speaking about the check, if it is not tender, if it is not tender for the payment in the bank, then it gets still within 30th, within 3 months, that is 90 days. So it is highly preferable. The lot of situation arises in the commercial situation कि people are not able to present the check in the bank for the remittance of the payment because the party is making subsequent promises over alternative durations. So in such a situation, there might be a chances your check might get stale and you might not be in a position to deposit that particular check. So my friends, you don't have to be afraid at all. If you are not able to proceed under the 138 of NI Act, you can easily institute the summary suit before the City Civil Code. The difference, merely a difference which is going to make while filing a civil suit or summary suit in the court and comparatively filing 138, is 138 is quite stringent as compared to the summary suit, and because we know as soon as the process notice and the process is issued, the other person has to be summoned and he has to be present before the court. If he doesn't appear on the subsequent date, the warrant can be issued in that particular matter. So for a layman, for everyone as a professional, I will like to say कि this pandemic is really a tough situation. I hope all the colleagues to stay together and get connected, and basically this is the right time you can dig with your books and get good knowledges. There are the few important points with respect to 138, that is respect to a jurisdiction of the matter, what is the drafting procedures. Subsequently tomorrow again I'm going to be there. Today at 9 p.m. I'm again going to take the seminar whereby I will be dealing with the drafting proceedings. So if you are interested,